NACDL is the association of the nation's criminal defense bar.
Try again. Good morning. I have very little to talk about and a long time to do it, so we're going to go ahead and get started. I want you all to take a second and think of a couple of cases that in your mind were great victories. And what comes to mind? How many of you, when you were thinking about the couple of cases that first come to mind, thought of a case you negotiated as a great victory? Okay, a handful. But, I mean, let's think about it. What is the trial rate these days is less than 5% nationally, and I think it's less in federal court than it is in state court. 95% of our cases, for most of us, we're negotiating, right? And we do get great, great victories for our clients in that situation. Many of us have developed patterns, habits, routines, etc. to negotiate, and many of us are very effective. But I think we can always go back and sort of look at the process and figure out how can we become more conscious about what we do. Because every now and then we get that sort of, that tricky one, that case that's a little bit different where this person's going to get this result unless we really figure out a strategy based on the research that's been done, based on the personalities involved, and based on the local culture where we're trying to achieve that great victory. So that's what we're going to talk about today. So the first thing is that I believe, for most people, if you actually sat down and looked at your career, probably 9 out of 10 of your greatest victories were negotiations. They just don't make it into the media, by and large. They aren't something generally we're going to be sitting around telling war stories about, and there's a good reason for that I'll get to in a little bit. But it's not the thing that you regale people with when you're sharing cocktails talking about how great you are. Nonetheless, to those clients, they were amazing victories. The first step, I think, though, to becoming better at what we do and to employing some of the research and some of the techniques is to have a consciousness about it, to really start to analyze the way we do a trial. You know, it would be nothing for us to spend days putting together a complicated cross-examination, even more than that, perhaps, for a difficult expert. But yet, oftentimes, we'll negotiate a case off the seat of our pants, not really giving it a whole lot of thought. This program that I put together came about a number of years back when I was still with the Public Defender's Office in Wisconsin. I went to law school, like many people, because I wanted to be a public defender. Wanted to help poor people accused of crimes by the government. When I got to the office, I had some thoughts about trial skills. I felt like for a young lawyer, I had some idea about what to do in a trial. But like most of us, I went to a law school where there was no negotiation program for criminal attorneys whatsoever. There was a negotiation workshop that all of us did in law school, I think as first years, that really was based on civil work, not criminal. So in the office I was in Wisconsin, I was assigned a mentor who was wise and grizzled and had been around for a long time. So I went to him to say, you know, Tom, this is a fellow by the name of Tom LeConte, just a great lawyer, still a public defender. This negotiation thing, I'm supposed to have a meeting today with a prosecutor for the first time on a case to talk about what we're going to do with the case. So what do I do? Now, as an aside, keep in mind, I was like many young public defenders, scarily serious, right? Eager to prove myself and much more prone to literal thinking than metaphor. At that point, metaphor was not my friend. So we go back. I go in, Tom, what do? I got to negotiate this case. He says, this is what you do. You tell them what the offer is. If they disagree, you say, fuck you, we're going to trial. Did I mention that I didn't really understand metaphor at that point in my life? I was quite literal and scarily serious. So in an office that averaged a trial and a half per attorney in the public defender's office, my first year in practice, I had 16 jury trials, which was sort of unheard of, right? The judge got so frustrated with me, he stuck me with 3 trials back to back to back. I had a Tuesday, Wednesday, Friday, Thursday off with a Monday jury selection for all 3. A couple things happened out of that. Number one, people thought I was pretty crazy, which in the long term has served me well, I must say. But I also got a lot of trial experience and won a few cases that probably the prosecutor didn't think you could win. So to that extent it worked, but that first year I really didn't learn a whole heck of a lot about negotiating. It was sort of trial by fire. So when a couple years later, when I started to think about the fact of, well, I've picked up some ideas now about negotiation, but is there somebody who's got a system put together, a training program? So Deja was one of the head trainers in Wisconsin at that time. And I went to her and I said, what if we were to put together a training program for the Public Defender's Office statewide to look at, in a thoughtful way, the negotiation process? She said, that sounds great. She reached out to all of the training directors around the United States she knew, and nobody had done anything. Nobody had done a thing for criminal defense or public defender negotiation. So we got some money, and I wanted to be trained in Washington with the negotiators who were working on behalf of the federal government, doing labor contracts, disputes, things like that. Did a 3-day program with them, came back with some ideas, and put together this program. So the first thing we want to do is figure out that we have a style, figure out what our style is. From then we can move forward, because once we are conscious of our style, we can use that style as a strategy. Traditionally, there were 2 forms of negotiating sort of personalities. Anybody here read any of the books by Fisher, Urey, Getting to Yes, Harvard Negotiation Project? So this was sort of a big change in thinking about negotiation when they first started doing this research. And this comes directly from their early work. People were either competitive, I would say, fuck you, we're going to trial, probably fits in that camp, or cooperative, where they was more about developing that relationship between the 2 people involved, the prosecutor and the defense attorney. And they break down sort of this way. Competitive negotiators look for high initial demands. They're going to be very limited in their disclosures. It's like playing poker, right? I'm not going to give you a whole lot. They give very few concessions. They create false issues. A prosecutor, for instance, might create an issue about not revoking a driver's license where that has nothing. So they're giving you something where you don't even care about that. There's threats, arguments, threats, for instance. If you don't take this agreement, I'm going to file a felony charge or an additional felony charge. We've all heard that. Commitment to positions or policy. And that's one of the hardest things we have to fight against, I think, with local prosecutors' offices, whether it's federal or state, is that they have these policy, well, this is office policy. And we'll talk a little bit about how you counter that, but that's a competitive position in elective disclosure. It wasn't until I left the Public Defender's Office and started doing some civil rights litigation on behalf of people with mental illness in jails and prisons that I really saw this. I mean, I see aspects of this in prosecutors, but where I've really seen this is in insurance defense attorneys. I mean, every single insurance defense attorney I've dealt with on a large-scale case, this is the approach that's taken. And so the other sort of style was to be cooperative. Foster trust, grant concessions, believing that, you know what, if I give you this, then you'll give me that, because things are just fair. I mean, all your prosecutors operate that way, right? As long as you're giving something, they're going to give something back, reciprocity, kumbaya. Positive motivations, competitive negotiating leads to resentment, and we don't want to have that, and expectation of reciprocity. So that, in very broad scope, general terms, is sort of the difference between competitive and cooperative. So just to give a little bit more detail, cooperative friends versus adversaries. The goal is friends. I don't want to destroy this relationship versus victory at all costs. I'm going to win. It's fair. As you look at this, think about the fact that both of these, in very different ways, are ego-driven. It's really about the personality, right? Make concessions, demand, soft on people, hard on both. Trust versus distrust. Changing positions easily versus digging in. Making offers, making threats, search for an answer the other would accept, search for an answer only the competitive person would accept. A few more: accept losses, demand gains, insist on agreement. At the end of the day, what you really want is agreement. I mean, that whatever we got to do to get there, we got to get an agreement, versus take a position, I'm not moving off this, I don't care what else happens. Avoid a contest of wills, again, getting into ego. Disclose the bottom line versus mislead about the bottom line. So this is what is called positional negotiating. Both these styles focus on a position taken by the other side and then haggling about that position. So for instance, and this is one of the key points of the talk, a position might be asking for 2 years prison. That's a position, right? So the prosecutor is saying, we can't settle this case unless either, wherever you're negotiating with, unless either you agree it's 2 years prison or you agree that I'm going to ask for 2 years prison, or you agree it's within a certain place in the guidelines, right? That's the position. And for all kinds of reasons that we're going to talk about, it's ineffective and it's ego-driven, and it's not based on anything that makes any sense. The opposite of positional negotiation or positional arguing is interest-based negotiation. That goes to the why, right? The why. Former prosecutors here. How's recovery going? We doing well? Not well. Stand up. Hello, my name is Keith. I'm a recovering prosecutor, right? Do you mind if I just ask you a couple of questions? All right, you seem like a decent person given your past. When you would ask for jail, prison, incarceration, generally speaking, what would be the reasoning to do that?
Well, it would be a variety of factors.
Variety of factors.
Person's prior record.
All right, their prior records. So why does a prior record mean you want to ask for incarceration?
Well, because I think you only get one bite of the apple.
You only get one bite of the apple, right? One mulligan, right? I hear that's a golf term. But dig deeper with me. Why is it the fact that if you've had a prior mistake and now you've done something stupid again, now you get prison or jail?
I think the prosecutor views incarceration as punishment. He doesn't do it for rehabilitation. He doesn't do it for deterrent purposes.
Okay, it's punishment, and that's a very honest answer. I'm going to tell you, when I talk to prosecutors, very few zero in on that point. Most are going to start with deterrence, right? Or they're going to talk about rehabilitation. That somehow, if I stick you in jail for a while, you'll stop doing it, right? That's worse than me shaking my finger at you. If we stick you in jail, then you won't commit the same crime. Deterrence. We all know this. This is basic criminal justice, right? But what we also know, and I'm sort of jumping ahead from some stuff I'm going to go back to later, what we also know, and it seems to me you know, deterrence doesn't work.
No.
It just doesn't work. The only way
Rehabilitation doesn't work either.
Rehabilitation doesn't work either. I may differ with you on that, and we're going to come back to that in a little bit, because there is some game-changing, I would say, research about rehabilitation that I'll put in terms of changing behavior. Rehabilitation in the concept of a prison sentence doesn't work for all kinds of reasons. But let's just look at deterrence for a second before we move to rehabilitation. Deterrence doesn't work because for deterrence to work, it has to be what two things? Anybody? Certain and swift. That's the only way deterrence is going to work. It has to be certain. It has to be swift. I did some teaching in China when they were starting a public defender's office. In China, deterrence works, right? It does. I mean, the crime rate is amazingly low. If you steal the proverbial, or for that matter, literal loaf of bread, you'll have a trial within a couple of weeks. You'll have confessed to the crime, because if you don't, it's a death penalty case. If you're convicted, you're shot the next morning. Your family gets a bill for the cost of the bullet that killed you. That's how quick justice occurs. Deterrence works. I don't think anybody wants to live in that sort of a society where we are arresting people, trying them within 2 weeks, convicting them on a confession that's either tortured or coerced based on the fact that otherwise you might get the death penalty and there's no right of appeal. So for those reasons, deterrence is not going to work, right? So we can leave that out of the equation. Rehabilitation doesn't work in a prison setting because prison or jail incarceration in and of itself does not decrease crime. If anything, for most people, it increases the likelihood of recidivism. I want to say that again. Because even as a defense attorney, it took a long time for me to get that into my noggin. Jail time, prison time, does not decrease recidivism. Not in any study, in any research that's been done. It could, if it was treatment-oriented, was between 7 and 15 months long, and when you got out of the treatment-oriented prison setting, you had the exact same wraparound services that you had in the prison setting. Otherwise, what we've done is simply teach somebody how not to get in trouble, how not to use in a prison setting. We've done nothing for them when they get on the outside. Because unless you live in a state that's much more progressive or smart, dare I say, on this stuff than my state, this is not happening anywhere in the United States. So prison and jail does not reduce recidivism. It only increases it in some circumstances. Which gets me back to this position. If we're going to talk about what the interest is, and I'm going to talk to a prosecutor, what's your interest in putting somebody in prison for 2 years, and they want to talk to me about deterrence, I've got to find a way to then address that interest, because that's a true belief. It's an erroneous belief, but it's a true belief. Or if it's rehabilitation, that's also potentially a true belief. But we have to get to the interest, because the interest is legitimate, right? Both of those interests are legitimate interests. Reducing crime and rehabilitation, those are all things we believe in as well. But what we're oftentimes talking about, quite frankly, is retribution, right? Or punishment, however you want to call it that. It's about the fact that sometimes somebody just needs to be punished, right? But there has to be realization, and this is going to come from us. It's going to come from us, and hopefully, eventually from the judiciary. It's not coming so much from the prosecution side of things. There has to be a recognition that, okay, that's a legitimate purpose for criminal justice is retribution or punishment. But I believe it's way overused, and I think most people in this room would agree with me about that. But you also have to understand that if you're going to use it for that purpose, then you're also increasing the risk of that person committing future crimes. So it's a balancing test. Do we really want to use it? Is that the interest? Is the interest of creating punishment for that person worth increasing the risk that that person will create more crimes? I want to give you there's an outline in your materials that covers all the stuff I talk about except this, the stuff I'm talking about right now. National Institute of Corrections is the place to go for all things doing with research on repeat behavior, repeat criminal behavior, and decreasing recidivism. There are things in there, if you look at, it's called I think it's called the education packet or something like that. There's one for prosecutors, judges, probation officers, that talks about all the stuff I'm talking about. The point for now, though, is that we want to get to the interest, not the position. It's not the 2 years versus 18 months that we really care about. It's the why prison in the first place. If they want to put somebody on probation for a first offense possession of a small amount of marijuana, does that seem like an outrageous offer? No, it doesn't seem horrible. Depending where you are, it might be wonderful, I don't know. However, it makes no sense if you look at the interest. What would be the interest in putting that person on probation? Well, anyway, what would be an interest of putting a first-time offender for having a small amount of personal-use marijuana? What would be the interest for putting them on probation? To do what? Stop them from using marijuana, right? That could be a good interest, right? Assuming you think people shouldn't use marijuana, which some people may disagree about that. But leaving that aside, assuming that that's an interest we have, then we'd want to find out, does putting that person on probation stop them from using marijuana? Well, again, if you look at the research for a first-time offender who's never been in trouble before, we want to do nothing. We want to get them out of the system as quickly as possible. Putting them on probation, again, the research will show, increases the likelihood that they're going to be involved in other crimes. This idea that when I first started as a public defender, a judge would say, you know what, I'm going to give you a night in jail because although you have committed no crimes the whole rest of your life, I'm afraid from here on you might become a career criminal, right? You were thinking about it, weren't you? I could tell. Get that look in your eye. I'm going to give you a night in jail so you know what it's like, and you're not going to want to go back there. It doesn't work. It's the opposite effect. That person is much more likely to commit a crime after that. So we want to get to what is the interest that the prosecutor has versus what is the interest we have. Well, every one of our clients has some interest in not wanting to be incarcerated, I assume, right? That's sort of obvious. However, different clients have different levels of that interest. Losing a job, losing custody of children, etc. Being made more likely to commit crimes by incarcerating is an interest not only does the client have, but we all have it, right? So once we start to understand what the interest of the prosecutor, then we can tie the interest to the community, which is after all their job, to be tied to the community. It never should be about this one person. It should always be about the community in some fashion, right? Okay. So that's interest versus position. We don't want to be sitting there haggling over 12 months versus 18 months versus 2 years. It's ineffective, and it really doesn't get at what negotiation should be about. Instead, we want to do principled negotiating. We want to separate the people from the problem. It's not always easy. A lot of what I'm going to talk about is going to suggest and motivate people to be very sort of Buddhist about this, very Zen mind-like about working with people who can be difficult, right? And by the way, they say the same thing about us, you know that. I know it's not always easy, but we want to try to get to that place where it's not about ego, it's not personal, it's about looking at what is the situation, what is the problem, what are the interests. We want to generate a variety of possibilities. If the interest is to make sure somebody doesn't smoke dope anymore, is there a better way to do that than probation that doesn't increase the recidivism for committing other acts? Right? So there are a lot of places that have first-time offender programs which are educational in nature. That's just an example. We want to generate ways of meeting the interest of the prosecutor while not getting in the way of the interest as much as we can of our client. We want to base results in some objective standard. What are other people doing in that community, right? This means we have to constantly be aware of what deals other people are getting, what this prosecutor's done in other cases. That one's sort of more obvious, but if we can start to look then more regionally, what about other areas in your part of the state, assuming it's helpful to you, right? If you're in the place that's the most progressive in your area of the state or your federal district, obviously you don't want to look to other districts. But you just want to constantly be thinking, what can I compare this to that's more favorable at getting to the interest? And then you have to have a best alternative to a negotiated agreement, which from now on I'll refer to as a BATNA. The BATNA I started with when I started negotiating. My BATNA was, fuck you, we'll go to trial, right? That's a BATNA, right? It's a best alternative to a negotiated agreement. Do what I want or we'll go to trial. The BATNA is the key to everything I'm going to talk about. You have to be willing to go to trial. You have to be willing to file motions. You have to be willing to make a whole hell of a lot of work for the other side. And if you say you're going to trial, you have to be willing to do it. One of the great benefits that I got, luckily, through my transition into negotiation was that there was no doubt in anybody's mind I would go to trial. Now, that wasn't a conscious decision on my part when I started, it's just because I didn't know any better, and I followed too closely the advice. But we can't get that reputation where you won't try the case. We've all known prosecutors who you know won't try a case unless they have no choice about it. It affects the entire negotiation process. You know, you just have to wait it out. You don't ever want to get that reputation. We have an agreement. We have a strong local criminal defense bar where I practice. And I have an ongoing offer. We meet once a month, shockingly, at a bar. We meet once a month at a bar, and I have an ongoing offer. Anybody who loses a jury trial with a verdict in less than 30 minutes drinks free for the night on me. The reason being is I want to, at least in a metaphoric way, encourage people to try those cases where there's no offer, even though you can't win them, right? That is all part of this process, to try to bring that percentage of trials back up, as long as it's not hurting the client. So again, principled are problem solvers. It's not about adversaries or friends. It's neither one. It's people neutral. Goal is a wise outcome. We want to separate the people. It's hard on the problem. What is the problem we're trying to solve? It's a negotiation in a criminal case. Proceed regardless of trust. It's not about trust from our point of view, although we want to engender trust on the other side. Focus on the interests, explore the interests, develop multiple options to accomplish the interest, invent options for mutual gain, insist on objective criteria. Why is this something that would be helpful? Again, that's when you can start to look at the research. The research for 90+% of our clients is really, really good. I'll come back to that. Reason and yield to principle. Reach an agreement regardless of will and avoid having a bottom line, because again, we're trying to look at what the interest is, not an arbitrary position. So, there are three main goals of principled negotiations. One, we're not haggling over positions. We want to stop doing that, right? We want to figure out how can we meet what the prosecutor needs to do once they've identified, we've helped them identify what they really care about, which isn't numbers of days of jail, or at least it shouldn't be. Build trust, and then preparation. So the first thing is not haggling over positions. Excuse me for one moment. Not haggling over positions. Haggling over position locks a negotiator to a position. How many of you have ever had an offer from a prosecutor, and in that moment you decided to do this, full-on assault about the position they took, and all it did was make them dig in even stronger, and they never forgot that position they took, right? Just three of you? I mean, I think that happens all the time, doesn't it? Because when a prosecutor takes a position, then we think this is bullshit. I mean, why would you make that offer? And we respond that way because we're human and we want our client to do better than this ridiculous offer. We really push that person into a corner, they dig in, it's much harder to get them off of there. That's why, for the most part, unless you've got an actual conversation going on, a dialogue, when a prosecutor makes an offer, it's the worst time to make a counteroffer. Think about that. Because it will feel like they're not, the prosecutor will feel like they're not being heard, that they're not being taken seriously, that you were listening just for the purpose of arguing back. How many people have experienced that in a personal relationship? Now, a few of you raised your hands. Now, let me tell you this, all of you lawyers. If I had your loved ones in here and you were out there, and I said to them, how many of you have experienced this with your lawyer partner, the whole room, most of the room would have their hands up, right? So we don't want to have that. That's why counter-proposing right after a proposal is ineffective, and actually the research on it, and there's research on this as well, is that it can make the negotiation last longer, make it much worse. Haggling over positions can engender ill will because you're not getting at what really matters. You're getting at something arbitrary that's about winning or losing. It's like trying to buy a car. We want to look for the underlying concerns. You know, I often, in presentations I do, I kid prosecutors, but the reality is the majority, great majority I would say, of prosecutors do this work for the same reason that we do, assuming that we still do it for some belief in what we do, right? I find that to be the same with prosecutors. To try to understand where prosecutors are coming from really changes that dynamic. You can start to see things from the other person's point of view. Now, I'm not talking about getting all touchy-feely. I'm talking about realistically, where are they coming from? What do they care about? I mean, it just changes that dynamic. These counter-proposals I mentioned already. So what are the interests of the criminal justice system? We already had this conversation with our former prosecutor. Deterrence, which for the most part for people in the criminal justice system simply doesn't work. Interestingly, what area of crime does deterrence work in the United States? Anybody ever thought about that? White collar. Who said that? Yeah, right? Tell me why.
Because these are usually people who have some moral foundation and understand that actions have consequences and
Yep.
worry about those consequences and what they'll lose.
Can everybody hear that? White collar, because it's about money. It's not about incontrollable actions. It's not about impulsivity. White collar, both for individual and particularly corporate, right? Corporate liability, deterrence actually works. A small handful of you have that come up as an issue. By and large, most of us aren't dealing with deterrence working in any meaningful way. Incapacitation. There is absolutely, in some cases, incapacitation is appropriate. There are some people that, at least, I've never represented these people because my people are innocent, but a couple of you have represented people who were scary. I mean, they were just scary. You may have won, you may have lost, but either way, at the end of the day, you were like, you know, I hope that person doesn't ever move next door to me because I really would prefer they don't. They're scary individuals. Sociopaths, until we can figure out a better way, Clockwork Orange sort of thing, ought to be incapacitated in a jail or a prison. Retribution, we talked about in terms of punishment. I use those interchangeably. Rehabilitation. So what is rehabilitation? It's nothing more than changing behavior, right? I mean, at root, that's what we're talking about. So how do we change behavior? Evidence-based decision-making. How many people have heard of this term? Evidence-based practice, evidence-based decision-making. This is the game changer I'm talking about. This is something that's been involved in medicine since the 1400s, where Dr. Lind, who went on the boats that would cross the ocean, he did a bunch of tests to find out why people got scurvy. So some people on the boat he would give like mutton, some people he would give salt water, some people he would give citrus, and he realized through evidence-based practice, evidence-based research, scurvy came from not having citrus, right? That's, as far as we can tell, where evidence-based decision-making came from. It's the model for medical use. That's the reason we don't use leeches anymore. We don't bleed people. The criminal justice system is only about 500 years behind, and we're just now starting to look at the research about how to change people's behavior and how that might come into effect in the criminal justice system. Anybody have a thought about why that's happening now? prisons, money, too crowded. It's not because all of a sudden we've become, enamored with trying to help people. It's because every state pretty much in the country has prisons that are costing way too much money. I mean, you all know that. It's in the news all the time. One of the leaders on this issue is Texas, not known as a particularly liberal state, as far as I can tell, coming from Wisconsin. But they're way out in front of this because of the cost of prisons and the realization that locking people up is not changing their behavior. All it is revolving door. So now there's an investment back into this idea. There's been research done on this since the 70s at least and 80s. A lot of the research has come out of a few places, either New Zealand or Australia. I don't remember which one of those. Canada and Ohio. Cincinnati, University of Cincinnati is doing a lot of work in this area about how do we change behavior through evidence-based practice or evidence-based decision-making, and that's a lot of what the National Institute of Corrections website has about what stuff actually works. And again, for 90% of our clients, this is really good stuff because what doesn't work is incarceration. It's counterproductive. So what we look at, once you start to look at this information, is there are three general categories of people. Low risk, as I stated already, we want to leave them alone. We do not want them in the system. They're self-correctors. Looking out at this crowd, I see a couple of you may have done some stupid things at some point in your life, maybe in college, maybe last night. Most of us, when we do something stupid, we're self-correctors, we realize, man, that was really stupid. I'm not going to do that again. And eventually that list of things gets smaller and smaller. There aren't that many more stupid things we haven't done. But we self-correct. Those are the people we do not want to put in the system in any way, shape, or form. The people that the main focus of treatment should go on are high and medium risk, where we want to use treatment that's appropriate to whatever their needs are. And there are assessments that can look at needs. I'm not going to go into that now. That's more for the social science people. But there are things that you can bring to bear in your system. I'm presenting this to you even though you may not have anything like this where you're at, because we need to push for this. And when you learn about it, it's stuff that you can use with a prosecutor to keep our people out of jail and, in the long term, help them. I mean, help them stop coming back. I mean, I got enough clients. It'd be okay if a few of them didn't get so many frequent flyer miles. On the other end, though, is extreme high risk. That's the clients that this stuff's not that helpful for. Because what it's going to show is that we really don't know what to do with them. There's some research that's suggesting that we might have an idea about what to do with somebody who has sociopathic tendencies, that actually an incredible amount of attention should be paid, even more than we do with the medium and high risk, where you have somebody like watching them all the time. But that research is just very new, and it's more suggests we might find something at some point. For those people, though, I'm sad to say, really, we don't know what to do with them. Incarceration logically makes some sense. But the great majority of people either fall in that green area, that's the biggest group, right? A lot of them we never see, thankfully, or the yellow area. So how do we change their behavior? Not through incarceration. I've already said that. Using appropriate alternatives to incarceration. House arrest can be really effective for people. It limits what they can do. You can do testing. You can do all kinds of things. And it doesn't create the environment that a jail does. Use appropriate individualized treatment. How many people have somebody put on probation and the judge has the laundry list of things and everybody gets all 10 different things? Get an assessment for this, counseling for that, whether you need it or not. That all gets in the way of effective behavior change. We have to get the right dosage for the right person is the terminology. So these are things we're trying to push forward to. Recognize personal and society costs of reentry challenges. This is a sort of new issue around the United States, and there's some grant money if you're in an area where you have access to policymakers at the federal level to bring in education, resources to look at reentry programming. But reentry coming out of a jail or a prison is at great cost to the person and the society. And the more you can hone in on that and talk about that as a cost and create that as an interest in the dialogue, obviously, again, that's going to be to the benefit of our clients. So second goal, want to establish trust through preparation and predictability. The idea of, and I'm not naive about this, for many of you, if you have large caseloads, some of the negotiations are just going to happen when they happen. But the more we can push ourselves towards being prepared, knowing the case, knowing the client, and being predictable. By that, what I mean is when I go to negotiate with a prosecutor, my hope is they're going to think Belzer's going to be prepared. I mean, if he tells me something, it's not because he's guessing at it. It's not because simply his client told him that. He's going to have done some background himself, and if he says it, it's going to be true. And I try to have that reputation, because just like a reputation for not going to trial, if you have a reputation for being creative with the facts, that reputation doesn't go away either. Demonstrate genuine concern. Of course, our main concern is for our client, and that's as it should be. But to also be a human being in the world, to have concern for the prosecutor, again, not because we're best friends. I'm not best friends with prosecutors, but I have a concern for what their function is and what they do, and I think it's an important function. I have a concern for the community. When you demonstrate a concern that's well-rounded, you're demonstrating an interest beyond just haggling over the facts in this case. Develop rapport, again, not to be best friends, but rather to actually have a conversation, person to person. Again, I know that's challenging with some people, meaning not you, of course, the other side. Preparation, the client interview, I think that's where it starts. You know, on the one hand, I think it's sort of cliche to say, you know what, I'm getting ready for trial from the first time I read the complaint or the information or meet the client. For me, the image I always use is two trains running. I got one running that's preparing for trial from day one, that's the BATNA, right? At least a BATNA. And the other one is also looking at negotiation from day one, even though I may not talk about negotiation with anybody. I think realistically, given the fact that 95% of cases settle, it would be negligent not to be thinking about both of those at the same time. Investigation and research, we got to know the prosecutor. You know, really, because I sort of, oh, yeah, it's fair. I obsess about this a little bit. None of you do that. A lot of defense attorneys where I practice will call me up and say, hey, what can you tell me about this sort of prosecutor in this sort of case? It's because I really want to know the people. I want to know the individuals. Some of you won't have that same interest, but you know, at least try to understand it. The victim, reach out to victims. It's amazing how often victims have a very different idea of what they'd like to see happen than what the prosecution is thinking or what they're presenting to you. And oftentimes, in my experience, victims are grateful that at least somebody's reaching out to them. Somebody's going to let them know when there's court again, right? I mean, you got to be clear ethically that you're not representing them, that you're not giving them advice. But every now and then you have somebody hang up on you. Okay, so what? But an awful lot of the time, they can actually be helpful in negotiation. At the very least, you're gathering information about where they're coming from. So if a prosecutor says to you something, say, well, you know what, actually I did talk to her, and that's not where she's at right now. The judges, you need to have a book on the judges. It does no good to negotiate what you think is a fair agreement based on interests, not positions, and then have the judge jump the deal. What are the fair standards, the conscious strategy? Brainstorm alternatives, alternative avenues to interest. There was some research done probably about a decade ago about good negotiators. Now, this is in the civil area, but I think it translates, compared to really like expert negotiators. They got rid of the ones that are below average. Good to expert. Expert negotiators don't spend any more time preparing for negotiation than good ones, but the percentage of that time they spend on brainstorming alternatives is much higher. It's just simply trying to figure out what are different ways that we can get to the interests that both sides want. And that's one of the things I really want to leave you with, is just to start thinking in those terms. What are the interests? How can we find another way to do that? This is maybe counterintuitive. We don't want to argue every basis for your interest. Now, if you've got an interest and you're trying to protect, and you have 5 arguments about why that interest is important, and this is what the interest is, and this is how we can present it, and 4 of them are strong, right? The 5th one, it's sort of strong, not all that strong. You can say, I might as well just throw it in there, just maybe that'll be what topples it over. Where does the discussion center in that scenario? And the last one, right? And the 5th one. Have any of you ever been in a disagreement with a loved one and you give 3 reasons why you're right and the 3rd one's weak? Where's that conversation going, right? The 3rd one, particularly if it was an unfair one, right? You know how that's going to go. So we want to be careful about just throwing in the kitchen sink all the time. It's not necessarily productive. Some general principles. 1, ask questions. This is the best advice I can give to you with regard to using negotiation as part of pretrial preparation, because of course we always have to have our BATNA. Asking questions. Why do you think that? Why is that your interest? I mean, why do you care about that? What does the victim think about the case? Is the victim still around, right? Why do you think your case is so strong? if we ask these questions in the context of developing rapport, so it doesn't seem like we're challenging, we're being ego-based, it's amazing the amount of information you could get that you don't know. How many of you tell the prosecutor everything you know about your client or about the weaknesses in your case? None of you, good, because that would be an ethics issue. We'd have to shut the doors. How many of you believe prosecutors, on the other hand, because they have an obligation, there is that Supreme Court case I heard of once, to turn over everything they know about their case? They don't. We have to ask questions to get that information out. Where are they coming from? Observe body language. For some of you, that's going to be something you can read more easily than others. Listen more, talk less. Again, the research on the good negotiators versus the expert negotiators. Expert negotiators talk 22% less than good ones. They spend most of their time asking questions and listening. Prosecutors are really used to defense attorneys coming in and just sort of giving the laundry list about, you know, my poor guy, Officer Krumke from West Side Story, for some of you who have ever seen that. You know, poor guy. That's not effective. Nobody's listening. It's not really how you create a dialogue. Let me say something so I don't forget. What I'm talking about when I talk about interest-based negotiation works primarily in a situation where you're negotiating with people you regularly negotiate with, right? If you're in a situation where you have a case in one part of the state and you get a case on the other part of the state where you're not likely to go to again, or if you do for not 5 or 10 years, the research is clear. The competitive negotiator, assuming you've got something to negotiate with, will do better, right, on that one case. If you take that position long-term in a legal culture where you do a lot of work, it's going to backfire, though, and it's not going to work. So this works in a situation where you're dealing with the same people on a regular basis, or, dare I say, we have not as good a case as the other side. That's where this also works. If you've got a really strong case, you know, you may engage in some of the information I'm talking about because it may be helpful, but you also, taking a competitive point of view, can be an advantage as well. So I don't want to be misleading about that. We want to really listen. Some of these I've talked about. This is an interesting one. Ascribe good reasons to prosecutor when you're not sure they fit. And again, the research supports this in negotiations. There may be times where we're sitting there thinking the prosecutor either doesn't really care about what they're saying they care about, or it's about politics, or it's about because their stash of baby bunnies that they strangle is out, so now they want to strangle my client instead. Like I said, I kid prosecutors. If we ascribe a good reason and talk about that good reason, oftentimes it's a self-fulfilling prophecy, right? Where they will then come along with that, and then you can actually have a conversation about the interests, even though it started with a position. When I engage in spirit of cooperation, cooperative brainstorming. I had a really difficult negotiation with a kid who was looking at a felony because he punched another kid in the face whose mother was the captain of the jail, fractured the guy's face, missed out on the rodeo championship for the state of Wisconsin. But I wanted to avoid a felony for reasons that I'm not going to take time to go into beyond just a felony. It was important. And at some point in a planned out 6-month negotiation, about 4.5 months in, I went into her and said, Amy, look, this is where we're at. This is what the interest is. I've talked to you about this before. I'm going to give it to you. Help me figure out how can we make this happen. And then she took it, and we did figure out how to make that happen. So that's something you can use as well. But again, that requires some sort of relationship. Test out creative solutions. Ask the prosecutor for help. Challenge your assumptions about the prosecutor. I've already covered that. But also, how many people have had either really obviously or in a more subtle fashion, prosecutors suggest that you're slime because you're representing a particular person, right? That you're less than they are. At some point, most of us face that. Challenge them in a thoughtful way. I mean, it seems like somehow you're being disparaging to me. I'm just curious, have I done something to cause that? And really, the putting that out in the open changes that dynamic as well. And focus, this is another thing. Again, this is the research. If you have areas of common ground, put some focus on that. It creates a sense of momentum, of moving towards resolution that can really help in the context of negotiation. What's something you can agree about, right? We want to avoid negative irritators. That's a ridiculous offer. How many people have ever said something like that? Oh, a lot more of you than that have. That is bad. Stop doing that. It doesn't do any good. Likewise, and we might not think of this as doing the same sort of thing, but saying, I'm being more than generous, right? That's a positive irritator. I'm doing something here. Why don't you help me? Yeah. So the question is, can you express shock sometimes if they make an offer that's outrageous, right? The research is that if you do that regularly, it's counterproductive, it'll hurt the negotiation, the person will dig in. But the research also is, and this is the interesting thing, if you don't do that, I mean, that's just not your approach to negotiation. If they say something shocking, you say, huh, I wasn't thinking that's where you're going to come from. Can you tell me more about that? You could have that response instead. However, if that's your style, to be thoughtful, and then all of a sudden there's a situation where the offer is so outrageous that you're like, whoa, that seems like so far out of left field. I'm really shocked by that. Then it has meaning, right? The people who are really good at this stuff, they don't take that approach unless it's really warranted, and they do it very, very seldom, because then it has a lot of meaning. Then it's not just some sort of negotiation, it's more earnest. When attacking defending spirals, well, yeah, well, then we'll go to trial. Yeah, well, then I'm going to add some more counts. Well, yeah, then yeah, all right. We want to avoid that. Provocative language, and that's what I was talking about just there. So, you can't see that very well. Darn, can anybody see what that is? Huh? James Caan as? Sonny Corleone. What the hell does that have to do with anything, other than the fact that I'm obsessed with the Godfather movies, at least the first and second? Well, how about this, though? Got to know your BATNA. Now, those of you who are Godfather fans, what did Sonny Corleone say that has to do with the best alternative to a negotiated agreement? Yes, absolutely. There it is. Sonny Corleone. No more. Not this time, consigliere. No more meetings, no more discussions, no more Sollazzo tricks. You give him one message. I want Sollazzo. If not, it's all out war. We go to the mattresses. That's the BATNA, right? You got to be willing to do it. You got to be willing to go to the mattresses. You know what? One of the images that works for me in this process now is the samurai warrior. The ancient samurai were never allowed to pick up a sword until they could paint, they could dance, they could write poetry. The reason being it was to be done with a just cause from the heart. They weren't supposed to cut off people's heads just because they could. But when they went to war, man, watch out. And that's sort of the image that now works for me. I'm going to be very thoughtful, I'm going to be very reasonable, we're going to try to get to interests. But if the other side's not going to do something that's interest-based, then we're going to war, and it's all-out war. I mean, it's all-out war. I think that's the way you got to look at it. So involve other participants. This is just some brainstorming of things I've done, and some of you, I'm sure, have done some of the same things. Involve a victim in negotiation if they're more in line with where you are than the other side. Again, just asking you to think outside the box. I've had numerous times call up police officers, what do you think of my guy? At least where I practice, the police get way too much authority on drug cases. I mean, drug cops are just a different breed from any other cop, at least in my experience. And so the prosecutors are always sort of like, well, I can't agree to that until I talk to the cop, the investigator on the case. So before we get to that point, usually I'll reach out to the investigator because they're going to not be as sort of cowboyish, for lack of a better term, with me generally, than they're going to be with the prosecutor, so I sort of get them on board earlier. Client, every now and then, and I just offered this in a case recently, this would be the only third time in 20 years, but I will offer the prosecutor the opportunity to meet with a client. Be really careful about that, obviously. I mean, you gotta, if you're thinking about it, rethink it, think it again. But in the right case, it can be really, really effective. Where do you negotiate? Again, just giving some brainstorming. You can do it, whoops, oh, they didn't come up. Well, you can do it at their office. You can do it in a hallway. You can do it maybe at your office. On a couple of occasions, I've had exhibits that I put together that were possibly for a trial, but really I wanted to get them to a different location to negotiate, where they didn't have all the phones ringing and everything else going on. I said, look, I got this exhibit. It's in my office. Why don't you come over to my office so I can show it to you? And then while they're there, we end up negotiating the case, and that's been successful. I'm not above negotiating over a martini as well with the right prosecutor. You got to think through if that makes sense in your situation. I really do prefer, though, I have a strong, strong preference for in-person negotiation. And I know in a lot of jurisdictions or a lot of cultures that's not really what's going on. But a lot of the stuff that I'm talking about, you can see it's much more effective if it's in person. So, oh, there we go. Their office, hallway, your office, bar. If it's not in person, these are the options. Telephone, I prefer that if I can't do it in person. The U.S. Postal Service, some people still actually use the Postal Service. And it's interesting nowadays to actually send somebody a letter, if it's not what happens regularly for offers, makes it seem more formal. It's almost like getting a registered letter now just by sending a letter. So in the right case, you might really spend a lot of time drafting a well-written, well-reasoned letter of negotiation. That's just something I've started to do very recently. I never used to negotiate through mail at all. A lot of negotiation where I am is through email, which I don't really like all that much, but if you have to do it, you have to do it. And is anybody doing any negotiating through texting yet? In the back? Yeah. None of them have gray hair, shocking. So I have never done that, but I assume that that must be coming around, right, or whatever social media there are. We want to close well, make it easy for the district attorney. Say, look, I'll take care of the arrangements, I'll get it set for a plea when you've got the agreement. Put it in writing. Put it in writing right away. Nothing worse than having worked out a good agreement and then they think about it later and think, what was I thinking? Get it in writing right away. Do not do anything to create buyer's remorse. If I'm selling a car and I listed at $1,000 and you say, hey, Belzer, I want to come look at your car. You come look at my car and you say, hey, can I just take it for a quick ride around the block? I say, sure. You come back, you say, man, I'm happy to give you $1,000. Here you go. And then you take off. How am I feeling about that sale? I could have got more, right? I could have got more. I feel like I got ripped off. We don't want to create that in prosecutors, which is why we don't brag about these great victories we call negotiations. If you're somebody that you trust closely, an office mate, that sort of thing, share that information. I'm not saying that, but you don't want to be talking about this in a bar where it's going to get back to a prosecutor. Nothing worse than a prosecutor later on thinking that they got hosed by your negotiation. Oh, nothing good can come when we show the Chicago Cubs. Some negotiations fail. Sometimes there has to be a winner. I mean, y'all in this room, many of you have cases that they're just not going to negotiate. Tried a case a year and a half ago now, son accused of shooting his mother and father in the back of the head for a multi-million-dollar inheritance. What the hell are you going to negotiate? I mean, that was a trial case. Sometimes that's what happens. Sometimes you negotiate too soon. I always try to tell my clients, we have to figure out the calendar here. If we go in too soon, it looks too eager, right? But you also don't want to wait too long. So you got to try to figure that out. An imbalance of power, one person's not prepared, becomes personal, become impatient, somebody's unable to move off a position. And I think more negotiations fail than we'd ever realize because of too much talking, usually on our side. So wrap up, we want to negotiate on interests, not positions. It changes the whole playing field when you do that. We want to creatively solve problems, not haggle. We want to enlist the support or cooperation of our adversary, unquote. We want to have a BATNA, as we heard. We want to go to the mattresses when necessary, and if you're going to go to the mattresses, go at it all the way. Thank you.